If you're a business owner about to sit for your deposition, you want to make sure you know how a deposition works. A deposition is the only time before a trial that the other side gets to ask you questions in real time under the penalty of perjury. Sometimes the other side will video record the deposition, and you can bet that they're going to be prepared to ask you all of the questions that matter for your case. This is why it's critical that you're prepared by reviewing all of the emails, all of the text messages, any contracts involved in your case, and prepare with your attorney to practice both the questions and how you're going to answer them in real time. This is something that I have done repeatedly with my clients. They've been very thankful because they've said multiple times that when I prepare them for a deposition, my preparation's actually harder than the deposition. And I think that that's what makes for good and smooth testimony at a deposition, is knowing the questions that are going to be asked or the types of questions that are going to be asked and practicing your answers. Because the other side is going to try to intimidate you at your deposition, you want to make sure you're prepared by knowing both the process, which usually starts with the other side giving you something called admonitions, which is warnings about the way the deposition proceeds, that you shouldn't guess or speculate during a deposition, that you should only answer based on your knowledge. And this is critical when it comes to answering questions, because a lot of lawyers will try to suggest answers to you or try to paraphrase your answers to try to get you to admit or accept something as being true that you didn't actually say. Whenever the other side tries to say back to you what you testified to, make sure you're listening carefully to ensure that they haven't added something into it or changed a word that changes the meaning of what you're saying. Because a lot of times what will happen is if the case doesn't settle, the deposition is going to be used at trial. They may play the video back to the jury and they are going to try to make it look like you're being dishonest in your deposition. This is why it's critical that you make sure that you understand the process. You want to make sure that you have gone over the answers and you've gone over how the other side is going to follow up on questions. So typical questions that are going to be asked at a deposition are questions such as, who else was there in that meeting? Why did you send this email? Why did you send this text message? What did you mean when you sent this email? What did you mean when you sent this text message? And they're going to talk to you about the various aspects of the timeline for your lawsuit, because again, what they're trying to do is get sound bites for trial. They're trying to get little clips that they can get to play to the judge or the jury to make it seem like you're not being honest to try to win their case. This is also a very unique situation because it's the only time other than trial where the other side has real-time interaction with you. So unlike written discovery, where you tell your answers to your lawyer and then they put them down on paper and then send them back to you and then revise them and then ultimately send them to the other side, a deposition doesn't have that kind of buffer. A deposition is in real time. They're asking you questions and your attorney may object, but if your attorney doesn't instruct you not to answer, you have to answer the question. Now, some of the best answers in a deposition are yes, no, I don't know, I don't remember. A deposition is not the time to have your Perry Mason or your Matlock moment where you're going to explain your whole case to the other side and they realize how brilliant you are and they just drop the case or decide to settle the case really favorably for you. This is not that moment. This is not that opportunity. What's going to happen if you volunteer information that wasn't asked about is the other side is going to keep following up and try to get more ammunition for trial. This is why it's critical that you stay tight in your answers. You keep your answers short to the extent possible. Ideally, if you can answer the question with a yes, no, I don't know, I don't remember, then answer it that way. Do not volunteer information unless necessary, and don't explain unless it's necessary, because the other side is just looking for ways to trip you up, looking for ways to make it look like you're dishonest, and looking for ways to help their case. So don't give them that opportunity. Don't volunteer information. Simple example I give to clients is if somebody came up to you on the street and asked you, do you know what time it is? You're probably going to tell them, if you know, what time it actually is. But you've got to remember that that's a yes or no question. And in a deposition, it's not like a casual conversation. You are not having a random conversation with a stranger or with somebody you know. You are having a conversation under the penalty of perjury where everything you say is written down and may also be video recorded and played back later. This is why you want to answer the yes or no questions, such as, do you know what time it is, with a yes or no, so that you're not destroying your case. If you have more questions about this, reach out to me. I'm attorney Parag Amin, and my team and I are happy to talk to you about it.